DAOs are a hot new legal entity type that burst onto the scene a few years ago. If you're looking to form one right now, we recommend staying away from them, and I'm about to tell you why. I'm Ted Sutton, and this is Direct Answers from Corporate Direct. Now, before we get started, please make sure to like, subscribe, and leave a comment if you have any general questions about anything. So what exactly is a DAO to begin with? Well, DAO stands for Decentralized Autonomous Organization. And the unique feature about the DAO is that they can either be managed by a human or they can be managed by a smart contract that exists on the blockchain ledger. My dad did a more in-depth video on DAOs a few years ago. If you want to give that a look, click the link right here. So as of right now, there are only 3 states in the country that have passed DAO legislation. In 2021, Wyoming passed the DAO LLC Act that treats DAOs very similar to how they treat LLCs. And in the past year, Tennessee passed legislation that allows for the creation of decentralized organizations, or DAOs for short. Also, Utah passed an act allowing for limited liability decentralized autonomous organizations to be created. We just use LLDs for short. Now, there are some pros to setting up these DAOs. One is that they can be managed remotely. As I mentioned before, they can either be managed by a human or by a smart contract that exists on the blockchain ledger. So it allows for more flexibility there. Another pro is that they have a more efficient governing structure. They can be managed either by humans or by a smart contract that exists on the blockchain ledger. In addition to that, voting is more flexible and it can be completed over a longer course of time. And another pro, or perceived pro, is that it removes management conflicts between humans. If you have a smart contract that governs the DAO, it removes any of the human elements that would otherwise exist in an LLC or a corporation. Now, by doing this video, I think it's fair to talk about the benefits. But as of right now, there are 5 reasons why we recommend staying away from DAOs, and I'm about to tell you what they are. Number 1, the smart contract is available for public view. Now, because the smart contract is on the blockchain ledger, anyone can see how your DAO is governed. In fact, if you set up a Wyoming DAO LLC, they require you to list the smart contract identifier when you apply to set up your DAO with the Secretary of State. On the other hand, if you set up an LLC or a corporation, the operating agreement and the bylaws are both private documents that are not available for public view. Number 2, DAOs can still be hacked. Over the past year, there have been several cases that have come out that have dealt with DAOs being hacked. One of them was called Sarkuni versus BZX DAO. What happened here is that hackers sent out phishing emails to the members of the DAO. The members opened the phishing email, and the hackers were able to access their private key. And with the private key, they took a whopping $55 million out of the DAO. You think that a smart contract would have stopped this from happening, but unfortunately that wasn't the case. On top of that, that same DAO was hacked 3 other times that resulted in $9 million being lost. So with this one DAO, $64 million was lost, and the smart contract wasn't able to stop those transactions from happening. Number 3, you can't use DAOs to evade the law. Because DAOs are a new entity type, there are a lot of people who think that they could set up a DAO to avoid other regulations, but that's simply not the case. The one case that dealt with this was CFTC versus Uki DAO. What happened there was that the owners had an LLC set up where they would trade currencies on the blockchain ledger. Then they transferred that operation from an LLC into a DAO so they could avoid any federal regulation. However, the CFTC filed suit against the Uki DAO, alleging that they were still subject to regulation. And what did the court rule? They ruled in favor of the CFTC, saying that the DAO is still subject to federal regulations. There's still people out there who will set up DAOs to do these same sinister acts. If you set up a DAO to avoid regulations thinking you're sly, think again. The feds will still come after you. Number 4, DAO owners are individually liable for the debts of the DAO. As it stands right now, there are only 3 states that have DAO legislation on the books. The other 47 states don't. And because there's no DAO legislation, a lot of court cases have held that they're treated as general partnerships, meaning that the owners are individually liable for any debts of the business. In the Sarkoony case, the court treated DAOs as general partnerships. And in the Uki case, the court treated DAOs as unincorporated associations. What both of those have in common means that if you set up the DAO, you're individually liable. And we don't want to put our clients in that situation. Another thing to note is that there's a lot of inconsistency here. One court treated DAOs as general partnerships, the other treated them as unincorporated associations. There's no clear guidance, and because of that, we recommend staying away from them. However, the best way to avoid this problem is by setting up an LLC or a corporation instead. Because if you set them up and you put money into them, if that LLC or corporation sued, your liability is limited to that money that you put into the business. That's not the case if you set up a DAO in a state that doesn't have them. And number 5, there's too much legal uncertainty surrounding DAOs. As it stands right now, there's only 3 states that have passed DAO legislation. On top of that, there's little to no regulations regarding DAOs, as well as little to no case law addressing how disputes are handled with DAOs. There's simply too many unknowns right now, and we don't want our clients to be the test case. As it stands right now, if you set up a DAO, you may be personally liable for any of the debts of the business. So right now, it's best to just stay away from them completely. Some of this may change over the next few years. Other states could pass similar legislation like Wyoming, Tennessee, or Utah. There could be other regulations addressing how DAOs are governed. And also, there could be more clear case law regarding how disputes are handled. But as of right now, none of that exists, and that's why we recommend staying away from them. There's simply too many unknowns at this time. And if you have any general questions about anything, please make sure to leave a comment in the description below. I'll see you next time.